In Chapter 3, we studied what the government cannot do to you. Those were fundamental rights, negative obligations on the state, restraints on power. Now we enter Chapter 4, and we flip the picture entirely. Chapter 4 is about what the government should do for you. Not must do, in the sense that a court can compel it today, but should do, in the sense that the Constitution considers it a fundamental obligation of governance. These are the directive principles of state policy. Let me give you an image that will help you hold both chapters in your mind at once. Imagine the Constitution as a contract between citizens and the state. Fundamental rights are what the citizen gets guaranteed. The state signs and says, I will not oppress you. I will not discriminate. I will not take your liberty without fair procedure. Directive principles are what the state promises to work towards. The state says, I will try to give every worker a living wage. I will try to reduce inequality. I will organize panchayats so your village can govern itself. I will protect the environment for your children. The difference? Fundamental rights are enforceable today in court. If violated, you can go to the Supreme Court under Article 32 and get relief. Directive principles are not enforceable in court. No judge will say the government violated your right to a living wage under Article 43 and must pay you the difference. This is why the Constituent Assembly member KT Shah called DPSPs a check on a bank payable at the convenience of the bank. You hold the check, but whether the bank honors it depends entirely on the bank's convenience. Another critic, Sir Ivor Jennings, called them pious wishes. These criticisms are real, and you must include them in Maine's answers. But they are only half the picture. The constitutional counter is equally important. Article 37 of the Constitution says the directive principles, though not enforceable by any court, are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Not just aspirational, not just advisory, fundamental, and a duty of the state. Moreover, over 75 years, the Supreme Court has used directive principles as powerful interpretive tools. The court cannot enforce a directive principle directly, but it can read a directive principle into Article 21. And once it is part of Article 21, it becomes enforceable. The right to livelihood derived from Article 39, which directed the state to ensure adequate means of livelihood, became part of Article 21 in the Olga Tellis case of 1985. The right to health derived from Article 47, which directed the state to raise nutrition and improve public health, became part of Article 21. The right to free legal aid derived from Article 39A. It became part of Article 21 in the Hussein-era Khatun case of 1979, even before Parliament passed the Legal Services Authorities Act in 1987. So while directive principles cannot be enforced directly, they have become the raw material from which the Supreme Court has built the expanded understanding of the right to life. Where did directive principles come from? They were borrowed from the Irish Constitution of 1937. Ireland in turn was inspired by the Spanish Constitution of 1931. India borrowed, Ireland borrowed Spain. This three-country lineage is directly tested in prelims. Dr. Ambedkar explained directive principles as instruments of instruction to future governments. He compared them to the instruments of instructions in the Government of India Act of 1935, which gave governors certain directions about governance objectives. The idea was to give every future government a constitutional roadmap. When you form a government, here is what you should be working towards. Now the structure. Directive principles are in Part 4 of the Constitution, Articles 36 to 51. Article 36 defines state for Part 4, using the same definition as Article 12 in Part 3. Article 37 is the key operative article that says DPSPs are non-justiciable but fundamental in governance. The actual directive principles run from Article 38 to Article 51. For exams, the critical facts are these. DPSPs are non-justiciable. Article 37 explicitly says no court shall enforce them. But they are fundamental in governance and create a duty on the state to apply them in making laws. They are borrowed from Ireland, which borrowed from Spain. Ambedkar called them instruments of instruction. They apply only against the state, not private individuals, unlike some fundamental rights. They cannot be suspended even during a national emergency because they are positive obligations, not rights with force of law to suspend. Now your MCQ. With reference to directive principles of state policy, which of the following statements is most accurate? Option 1. DPSPs are justiciable and can be enforced in courts just like fundamental rights. Option 2. DPSPs are non-justiciable but are fundamental in the governance of the country, and it shall be the duty of the state to apply them in making laws. Option 3. DPSPs were borrowed from the Constitution of the United States of America. Option 4. DPSPs apply against both the state and private individuals, making them similar to horizontal fundamental rights. Think carefully. The correct answer is option 2. Article 37 says DPSPs are not enforceable by any court but are fundamental in governance, and it is the state's duty to apply them in making laws. Option 1 is wrong because DPSPs are explicitly non-justiciable. Option 3 is wrong because they were borrowed from Ireland, not the USA. Option 4 is wrong because DPSPs apply only against the state, unlike some FRs with horizontal application.